All right. Screen share. All right. All right. So again, good afternoon. This is Simon Casares, team leader, broker of record for the Torrance office and also the Long Beach office. Thanks again. Happy New Year's to each and every one of you. This is our first official contract class of the year. So yay, thank you so much. So today's topic is going to dive into assignee and nominees. What are the difference between the two? Now, as we go along, if you have any questions, by all means, please raise your hand or say, Simon, hey, I have a question. It's pretty detailed in the explanation and how the contract works. I'm going to also dissect the paragraph that the purchase agreement has, which is paragraph 23, that talks about assignments, okay? When you represent a client, or if you're the listing agent and get an offer, right, that has an assignment, all right? So let's dive into this. All right, so what is an assignee and what is a nominee? An assignee is generally understood to be one who contractually agrees to assume or take over the burden of the original responsibility of the party. So basically, I am buyer A, right? Buyer A eventually decides that buyer A doesn't want to purchase the property and now wants to either assign it to another party, or an assignment is also where an owner, a buyer, wants to maybe now include a corporation. The buyer now wants to assign it to a trust, okay? And then the difference between assigning and then what is considered a nominee, okay? A nominee is generally understood to be one who is appointed by the original responsible party, but who has no contractual agreement to assume those responsibilities. Remember, after everything that I've mentioned, the seller still has to give you the okay, because the contract also says that if the seller does not agree to the terms, then you cannot assign it. And then also the difference between that is who is still responsible if the buyer has originally put a deposit. It's not like the buyer could say, look, I assign it to buyer B. Now I want to pull my deposit. Okay, it doesn't work that way. And I'll explain the pros and cons and really the illustration and an example as well. Okay. So in a real estate transaction, typically the assignee or nominee becomes the buyer in place of the original. So as I mentioned, Simon Casares is the buyer buying a piece of property, and that can be single family, duplex, triplex, fourplex, multifamilies, more than 5 units, commercial, even land, business opportunities, right? All those factor into an assignment. There's also a new form that came in fact, and that form is the AOAA form, okay? And then I'll explain how that form works when we have to exercise that assignment. So what does it matter? Why does it matter? Because a nominee is not legally obligated to complete the duties of the original responsibility of the original party. If the contract permits the buyer to nominate another to take its place, there is not an enforceable contract. So remember, everything that you do in respect to the purchase agreement is based on the buyer and the seller, right? And then when there's mutual agreement, meaning that the buyer submits the purchase agreement and after back and forth of counter offers, right, both parties mutually agree to the terms of it, then it becomes enforceable, right? Now there's patterns and responsibilities, right? The buyer's responsibility to close the deal, but the buyer also has responsibilities to, get the proper financing if there's finance involved. The seller's responsibility is to make sure that they're following the procedure to sell and then ultimately transfer of ownership, right? And part of the seller's responsibility is also providing known disclosures, any material facts about the property, and more so making sure that they get paid off their loan, and then the recording of the property and the exchange of ownership, right? So there's responsibility on both parts, not just from the buyer's perspective, but also from the seller's perspective as well. If a listing broker brings a buyer who writes a full price and terms offer in the name of a buyer or nominee, the broker may not have earned a commission for procuring a ready, willing, and able purchase because the offer is uncertain. So basically what it is remember, as I said earlier, the seller has to give you the approval, right? So on the purchase agreement, if you are representing a buyer, right, you're going to put a buyer or multiple buyers, but you're also going to add this wording, assignment or assignee, okay? So Mr. Smith, Mrs. Smith, or assignment or assignee. Okay, so that opens up the conversation now when the listing agent receives this offer, is that there may be a chance that this may be assigned to a different entity or different person. Now, spoiler alert and red flags too, because again, when an offer is submitted and an offer has or assignee, in my opinion, is there may be a chance that the buyer will not complete the transaction. Most probably have heard what's called wholesaling, okay? Wholesaling means is that a particular buyer investor submits an offer, ties up the property, and then eventually finds another buyer that will complete the transaction, okay? And that wholesaler will also collect a spread, okay? For example, I am looking at the MLS, I'm an investor or I'm an agent, right? I find and identify a property that's in bad condition, but I secure it and I go with the motions that I'm going to submit an offer, right? If it's me as the person or me as an entity, a corporation, S Corp, C Corp, or an LLC. But my intentions are not necessarily to purchase, but my intentions is to secure the property, find an end user, someone that will actually purchase and complete the transaction. So I want to be very clear and concise that my intentions is possibly me purchasing, possibly me assigning that agreement. Now, when you submit the offer, that needs to be disclosed from the very beginning. Because if you don't add that language, the seller may decline that request. Now, that's also a negotiating aspect too as well, because the seller again has to agree to allow you to assign it. Okay. Now, for the sake of argument, you can also include a position of communications, right? You're going to pick up the phone, you're going to speak to the listing agent, and you're going to tell them the intent. Maybe the intent of adding that is that the buyer may not know certainly if they're going to put it in a trust, or uncertainty that they're going to put it in a corporation, or maybe they're trying to create a new corporation because this may be an investment property. So I would, be in communications with the listing agent, because right immediately it's going to send an alert to the listing agent. If I was, the receiving party here, receiving an offer, I'm gonna be looking at that very cautiously, but also more so asking a lot of questions. So as the buyer's agent, you want to be proactive and reach out to the listing agent and say, hey, just for clarity purposes, the intent of my client is to ultimately either put it in their trust or create a corporation. So now you're putting some clarity to the listing agent. The listing agent now can coincide and provide that information to the seller. And for most of the time, that shouldn't be a problem. The seller will be okay with having that assigned to an entity, okay? Where it gets a little concerning is when the agent and the buyer intent is to wholesale it, Okay. And as a listing agent, your number one priority is to dive deep in that conversation and ask the right questions. Because I've seen it most of the time where the deals fall apart because the buyer's real intent is not to purchase, but to find an end user and ultimately wholesale it to someone else. And because they don't find someone, then the deal falls apart. Now you're back to square one. And unfortunately, you just wasted maybe 10, 15, 20 days. So you want to be proactive in your position and ask the questions, because again, the problem here is you may not be able to earn a commission. And if the seller can find that loophole because the uncertainty of assigning it to someone else, then the seller can say, well, argumentally, you didn't find a ready, willing, and able buyer. So what does the car purchase agreement say? So the RPA and all other car purchase agreements allows the buyer to assign. It does allow, and there's specific language that allows it. And I'm going to show you two areas in the purchase agreement that says that you're assigning it, and then the actual language involved. To a third party with the written consent of the seller. And that's very important for you to understand. It has to be consent by the seller. It has to be approved by the seller. The seller's consent shall not be unreasonable withheld. Basically, they cannot say, oh, no. It really just depends on what the assignment is. Okay, as I said earlier, is the buyer's intention to maybe send it to a corporation, create a new corporation, or maybe a trust. Okay. Unless Assignee is the buyer's own trust or owned entity, right? So the corporation. Whether consent is required or not, the assigner must disclose to the seller the name of the assignee and any consideration the original buyer receives for the assignment. The assignee must qualify with the lender the same as the original named buyer. And the assignee must be already be in existence at the time of the original contract is signed. So there you go. Where's the disclosure? You're putting it from the very beginning on the very top of the RPA, the first page of buyers. You're going to put, the name of the purchaser or assignee. Or you can be as specific and say it's going to be the name of the buyer or a corporation or a trust, right, as an assignment. Whether consent is required or not, the assigner must disclose to the seller the name of the assignee and consideration of the original buyer receives for the assignment. The assignment must qualify, right? So part of that is that, in order for the buyer to assign it to a different entity or different buyer, the buyer shall be in a position that they qualify, okay? Because the last thing you don't want to happen is that the deal falls apart because the second buyer may not qualify. And you as a listing agent have every right to get as much information about the party that they may possibly assign it to. Now, with that being said, when an original offer is submitted, and it has that language where it says Mr. and Mrs. Smith or assigning, right? As I said earlier, you want to get some clarity, okay? And the buyer and the buyer's agent should give you known disclosures regarding that. Is the intent for the buyer to really purchase? And most buyer agents are going to say, yeah, the intent is there, okay? But what they're doing is also looking for an opportunity to maybe wholesale it to someone else. Now, as I said, the whole benefits of doing a wholesale is that the person that secures the property, right, is in contract, right, has disclosed to the seller and the listing agents that they may possibly assign it. Then there's the benefit that the buyer may get a wholesaling fee. Let's say, for example, Jimmy, right, that you are the buyer and I'm the buyer's agent, but you're an investor. And after looking at the property, you want to submit an offer to me, right? or to the listing agent. But you also may have the intent that you have an exit strategy. If the numbers don't make sense, you might be able to now assign it to someone else. Maybe someone that has more intent. Maybe it's a property that needs a lot of work, right? And your estimate of repairs may be over your budget, or maybe your calculations were off and you don't have the means or the financial position. But it gives Jimmy an example of him and the ability to assign it to someone else. Now, with that being said, let's say that Jimmy finds another investor that's willing to buy it. Let's say that I buy the property and I have it tied or in escrow for $800,000, right? But the actual estimate to get that to after repair value is going to cost me an additional $200,000 from the 800. Okay. Now that might be a big amount of money that Jimmy is just not in the position to do so because he doesn't have the capital to start the rehab. So now Jimmy says, let me find one of my good investors who might be in the position because they have the capital and it may be a benefit to the new buyer. So now Jimmy goes to John and he pitches the property. Hey, I got this property locked in. I have it in contract. Are you interested? John says to Jimmy, yes, I'm very interested. Give me the address. Let me take a look. Let me run numbers, and then I'll tell you if it's something that I can do, right? Well, because I told John about this, I can actually what's called wholesale. Okay, it's far and few, but does it happen? Absolutely. Is it legal to do so? Yes, as long as everyone is on the same page and everyone knows their intent, right? Disclosure. Now, Jimmy has it secured at 800,000, right? But now I'm going to wholesale it, meaning Jimmy is going to wholesale it to John. And now John is going to buy it, say, for 820. Okay. So there's a spread, right? The spread of what Jimmy bought it for, secured it at, and what he's going to wholesale it to the end user, the wholesaler, right? To now John. John, after doing the numbers, makes sense. Maybe John has some good contractors and has a more specific on that amount, where Jimmy's amount was about 200,000, but maybe John's is 150,000. To do the renovations. So Jimmy and John come to an agreement, and John says, yeah, not a problem. I can do 820. Okay. So what's going to happen is now you consider that wholesale position, right? Jimmy at the end of close of escrow will get a check for the difference, right? Which would be 20,000 from the 800 purchase price and the 820 that he wholesaled it to John, who is the one that's actually going to buy the property. And then John closes, starts the renovations, and then after he did his renovations, puts in the money. Now he puts the property on the market, sells it, makes a profit. Everyone wins. Jimmy gets his 20,000. John renovates the property, puts it on the market, sells it, makes a profit. You make the commission, everyone wins, right? So those are what we call assignment of agreements, okay? So in essence, the contract allows you to do so, but it also allows the buyer, the original buyer, to stay in the involvement of it, the contract, even though all in any paperwork is going to now coincide to the new wholesaler or the new buyer, right? There has to be transparency, and obviously any disclosures that the seller provided needs to be transferred over to the new buyer. But escrow needs to know, and also the seller and the listing agent needs to know, because ultimately that person may have a different corporation or LLC. So that way, everything is as smooth as possible, right? Steve, you have a question?
I do. And the question based on, because I have not been involved in a wholesale assignment, but it would be under my assumption if it was a wholesaler buying it, that a wholesaler would just assign the contract to buyer B, and buyer B would then pay the premium to buyer A, who the wholesaler, outside of the escrow, because in essence, there could be negative consequences if all of a sudden now you're needing to get the seller to agree to a purchase price of 820 instead of 800, from a tax standpoint of gains and all that, you know. But is it done through escrow as opposed to an investor A or investor B paying investor A outside?
You know, that's a very good question. Based on what I know in my knowledge, Steve, is that most transactions that do have an assignment need to be involved in the transaction. Meaning I can see it from both sides, right? The benefit and not the benefit, right? The seller says, well, wait a minute. I thought I'm selling the property for 800,000, but now I'm closing with a different buyer at a different price, right? Now, I'm not going to go too deep and too complicated on this, but you know, everything that your intentions are, one is disclosure. If a buyer is buying the property below value, right, you want to make sure that you're disclosing. No difference than when a buyer is also licensed, right? That if a buyer is buying it for the intent of purchasing it for a profit, I would probably, you know, for legality, I guess is the word, would disclose that, because you don't want the seller to come back and say, well, wait a minute, you know, I wasn't aware that one, the buyer was licensed, two, that I felt like I was taking advantage, right? And I've seen cases like that, Steve, where, you know, the intent is, yeah, the property is in really bad condition, and I get it. You know, that's why you're going in there to fix it, make it as pretty as possible, right? So that way the buyer can now turn around and sell it and make a profit.
I understand. I understand. Matter of fact, actually, I had my first assignment probably in 25 years, a year ago. Okay, where I was the listing agent on a property here in Torrance. It needed fixing, and it was buyer investor A who entered contract as a cash deal, and halfway through the escrow at that point, he realized his money didn't become as liquid as he had hoped for, and that he needed to assign the contract. Okay. And so, and he did, and he assigned the contract, and whether there was any outside transaction between buyer A and buyer B, assignor and assignee, at that point, I had no idea, and nor did I care. Okay. All I cared, you know, as the listing agent, was that the contract got assumed, and buyer B, who assumed that contract, was going to then adhere to the same price and terms that was initially agreed upon with buyer A, who then assigned it to buyer B, you know, in that way, and which it was done, and we closed escrow and everything was fine, you know. So, you know, it almost seems to me, you know, that it's a lot more complex, and where as a listing agent, you don't need to be involved with, you know, buyer A does not, you know, he then just bows out of the equation once he assigns the contract. And if there's any transactional relationship between buyer A and buyer B, or assignor and assignee, that's on them outside of the escrow, you know.
Yeah, no, good valid point there. Here's my concern with that, and this is where the liability comes into play. Now, and I've seen it both hands, and thank you again, Steve, for really sharing that, because you can see it from two different perspectives. One, I can cut a deal with the new buyer who's going to step in and handle and close the transaction. You can pay me on the side. Hey, you know what? Here's what I'm going to be making, $20,000. And, a lot of investors go ahead and do so and cut a check. And now you're clean, you're out. This new buyer takes over. From a listing perspective, if we have that language that says buyer or assignee, that already is an alert in my opinion. And I'd rather have all of that part of the transaction, because again, at the end of the day, it's all about disclosing, everyone's intent, which is the intent is to fix the property and to, turn around and possibly sell it for a profit. So there's three elements to that I see. One, what are we disclosing to the seller? One, if the property is in bad condition, they're either going to throw a lowball offer, or if the listing agent is seasoned, they're going to know that based on the condition of the property, it's going to sit on the market, for weeks or even possibly months, right? The whole intent is for the seller and the listing agent to sell the property, right? And how many times have you been on properties that are in really bad condition, right? It's what we call the after repair value, right? What is the condition of the property if the property was in move-in condition? Now, with that being said, for me, I'm looking at it from a compliance perspective, is that if the a person is assigning it, I'm already target, right? Because I know that buyer A has already submitted the offer, so we know who buyer A is. Now the assignment to buyer B, if they're going to exercise that right, and again, the seller has to know and the seller has to agree to it, right? I would rather just keep everything in the transaction, so for tax purposes and ultimately transparency, and more so to protect our license, if we are involved in that transaction. Maybe you're representing both the buyer and the seller. Now, the illustration, I think, goes into that it has to be disclosed. I remember reading this as part of the presentation. So let me continue, and then we'll pause for a bit on that, and we'll circle back, because I believe there's language in there that says that, if we're going to assigning, you want to keep it within the transaction. So why would a contract provide for the nominee rather than the assignee, right? A contract provided for a nominee might be enforceable if both buyer and seller understood that the buyer was going to create an entity after the contract was signed, and therefore closing transfer the contract to the entity, right? And that entity can be your corporation, S Corp, C Corp, or LLC. In that case, both buyer and the seller could say to have agreed to the buyers would be in good faith to set up the entity, and the contract would fail if for some reason that was not possible, right?
Are you screen sharing, by the way?
Yeah.
Interesting. I don't have it on my screen, even though it says Simon is screen share. Anybody else have it on their screens?
Let me pause. Let me try again. And
there we go. Now I got it. Now
yeah, I have it the whole time. Thank you.
Well, no one said anything, so I mean, I have it on the screen.
There you
I thought it was neat because I'm in my car.
All right. Well, thank you, Steve, for
there we go. Thank you.
So the seller has the right to disapprove of the entity. The nomination acts sort of like a contingency. That type of mutual agreement could create a valid contract, right? So, but is that what most sellers would expect? Others' possibility would be if the nominee was acting as a mere agent of and for the named buyer, the way many people think of a revocable trust. Since seller consists is not needed to assign to a buyer who solely own entity. So again, if you are assigning it to your own personal, then it's not like the seller can say, no, I don't want you to do that. You're still involved in the transaction. You're still going to get the finance involved. You're still going to have all the terms of the agreement, right? Which is contingency removals and all that. It's when it gets assigned to a different person, right? So easy done before a contract written. A contract in the name of the buyer or nominee is generally not needed. Any advantage of doing so could outweigh by the risk of creating an unenforceable agreement. So as many of you know, that December 2022, the contract was revised, right? And now the nominee is interchangeable with the assignee. Most residential parties and real estate practitioners do not understand the implications of writing or nominee into a contract, yet the practice persists. The December 2002 version of the RPA has language to address that bad practice. A nominee will be treated the same as an assignee and shall follow the same procedures, requirements, and terms imposed upon an assignee by the contract. The nominee effectively means the same thing as assignee. If any other meaning is intended, the nominee language should be prepared by legal counsel. Okay, so let me pause for a minute and now let me bring up some language that I have. So on the purchase agreement, where did it go here? Okay.
There you go.
Wow. Well, I had it in my.
We're there.
I'm telling you, Steve. Love technology, but then technology can also be a pain in the rear.
Yes.
All right, let me continue and see if I can get it back on here real quick. So continue.
While you're doing that, Simon,
Mhm.
just so I understand correctly, is it a requirement, like, can you just use the words assignee or nominee if your intention is to put it into a trust, or
No,
you have to indicate?
no,
what-
you don't. If the intent is to put it into your own personal corporation or a trust, then you don't have to include it. We encourage you to do so because you can now do an addendum. Where you really want to put the assignee is if the intention is that the buyer may not be 100% sure that they're going to purchase the property. They want to have that backup exit strategy where they may be able to assign it to a second party.
But they're still, by virtue of entering the contract, are they still required to follow through on it?
Yes.
Okay.
Yeah.
So it's not like it's an out.
But it can be, but when you're a listing agent and you receive a contract with the word nominee or assignee now on it, that could and should be almost construed by you as a listing agent with some trepidation, like, do we have an issue, especially if it's a cash buyer investor?
Right.
All right. Typically speaking, whenever that is done, typically the word cash is the issue at hand.
Mhm.
Okay. Very much what I had in my example that I had a year ago. Okay. Even though they provided documentation of the funds. And so, you know, it's definitely one in which it definitely raises some red flags that investigation needs to definitely be delved more into it. Okay. You know, what is the reason? Where are your sources? And you want to ask a lot of questions, you know, surrounding that.
Yeah, thank you, Steve. If you look at the page 2 of the RPA section K23 right here, right? It already has that language that says assignment requested. It doesn't say yes or no, but it already has assignment requested, and it also has a 17 days after acceptance. Meaning that the buyer, if they are planning to exercise that assignment, they have to do it within that time frame. Okay. Anything after, the seller can decline and be breach of the contract. But if the buyer wants to assign it, then based on this, the buyer has 17 days to do that assignment request. Now, also with that, you know, the information here where you put the buyer, you're going to put the buyer or assignee. So that's already something that you're divulging, disclosing to the seller as, okay, you know, you're being proactive, but also the listing agent is going to see that, okay, now I'm going to have to dig in deeper and ask more questions, because now what is the real intent here? Okay. And again, if it's its own entity, if it's its own trust, then you don't have to put that as an assignment, but it's best to do so for clarity, but you don't have to. It's only when the intent is, or the option that the buyer may exercise of sending it or selling it off to someone else.
And that states in clause 23 of the contract. Clause 23 states it that
Yep.
if it's going into your own family trust and all that,
Exactly.
no assignment is then needed.
Exactly. That's
Does that assignment for family trust have to take place during the escrow if there's a?
It doesn't have to. It doesn't have to. You can do it after close of escrow and add it into your trust. So 23 right here. You guys see this? Assignment. Buyer shall have the right to assign all a buyer's interest in this agreement to buyer's own trust or to any wholly owned entity, right? Like a corporation, LLC. A buyer that is in existence at the time of such assignment. Otherwise, buyer shall not assign all or any part of the buyer's interest in this agreement without first having obtained the separate written consent of the seller to a specified assigning. Okay, so remember, you got to distinguish what this means, right? Because yes, you can assign it, but yes, you have to get the approval if you're going to assign it to a different party. Okay, so where am I at? Seller, the name of the assignee, and the amount of any monetary consideration that the buyer and assignee. So there it is, Steve, right there is that you're divulging that information. So if I'm buyer A and I'm going to wholesale it to buyer B, and I'm going to make a profit for wholesaling it of 10, 20,000, what the contract says here is that we have to divulge that information. Seller, the name of the assignee, right? The seller, we have to let that now. Simon is not going to buy the property, but Jimmy is going to buy the property. But it also goes into and says that the amount of any monetary consideration between the buyer and the assignee, buyer shall provide assignee with all documents related to this agreement, included but not limited. So there you go, Steve. And I get it, because sometimes I've seen deals happen outside of escrow. We just get one clean buyer comes in, boom, and then the seller doesn't necessarily know.
Right.
But they still know, because once they buy it, they're going to see the increase of the price. So it's not that you can get away with it, right? Or where I've seen too is that the buyer steps in at that 800 as an example, right? We wholesale it for 820, but the buyer that's going to step in and close out the deal will still be in at 800, right? But now writes a check. But my concern with that is now we're not divulging and disclosing that, and that's not the proper way of doing it. Does it happen? It happens all the time. Okay.
Well, I think it's still done that way, but on the basis that there's still disclosure. Okay. In other words, at that point, it's still closed at the initial contracted price of 800. Okay. It's just that now seller now has full knowledge and consent that, okay, that he's flipping it to the other investor, making a profit of X dollars,
Absolutely. Yes. Then it goes, furthermore, the agreement and any disclosures, if assignee is a wholly owned entity or trust, where am I at? Trust of the buyer, then the assignee does not need to re-sign or initial all documents. So if it is your own personal entity or corporation or trust, you don't have to redo all the paperwork because you're still involved in that transaction. Make sense?
My only question from that perspective is, does that assignment have to take place during the escrow time period?
Oh, yeah.
Or is so let's say you wanted to put it into trust, that was your intention right from the start, but you're creating it at the time that you buy it and it's not ready in time. So does that delay escrow, or Is there like a
Well,
financial?
Yeah,
issue?
there is, yeah, I mean, the only thing may be what we call an extension of the escrow. If, let's say, the intention of the buyer is to put it in a trust and, the buyer has spoken with maybe an attorney, they're drafting the necessary documentations. And that it's not going to be done, and that the close of escrow is happening in a week or 2 weeks, you can do a couple things. You can extend escrow and, put that request, the buyer's intention is to, put it in a trust, right? But the pros and cons on that also is if they're getting a traditional finance, the lender may not allow it, till after close of escrow. Okay, because they're not financing an entity, they're financing the buyer who has, the bank information, credit score, employment, right? So most people that do trust typically will probably do it after the deal closes. Now they create a trust and it goes into, the Casares family trust. Okay. Or if it's a trust, maybe, maybe your parents left you with millions of money in a trust, right? And you're using that to purchase the property, then again, you'll probably indicate that as the primary buyer, not necessarily you as the person, as an assignee to the trust. You're just going to buy it, Casares trust or something to that nature. Okay.
I know whenever I'm a listing agent, as an example, the answer to your question is to the question of if it takes more time to be able, if the buyer wants to put the property into their family trust and it would require more time. When I'm a listing agent, if that were to be requested, my advice I would give my sellers is no, we're not going to delay escrow. Well, the recommend close it in the name of the individual. And if they want to put it in their family trust, once they close escrow, that's on them. But we're not delaying escrow for you to be able to put it in your trust.
Yeah, I mean, it really boils down to the seller, right? The seller has to make that initiative, right? Not the agent itself. So if the seller says no, then we have to abide by that. But if the seller says, okay, you know what, it's only going to be an additional week or so, then, we have to go based on that as well. So, but again, I've seen where buyers put it into a corporations. Corporations can be done if you have the right CPA or accountant. They can create a LLC, and then I see a lot of transactions being done that way during escrow. If the buyer intention is to put it into a corporation, maybe it's an investment property, maybe it's a rental property. They don't want to include it in their personal. They're doing a corporation to kind of shield that, and I've seen that happen too. If that's the case, then you don't necessarily have to put our assignee. You just do an addendum clarifying that, my intentions is to put it in my own personal corporation. Jimmy, you had a question, sir?
Yeah, and you do that during escrow.
That's correct.
Okay.
That's correct.
Second question I had was, if buyer A finds another buyer with 20,000 more, gotta get approval from the seller. It would seem to me that the seller would say, yeah, let's do it, but let's split the profit in half.
Well, I can see red flags, when it comes to wholesaling, right? And this is what Steve was saying as well, is that one, we are disclosing to the seller, right? One, if you're buying as an investor, you're licensed, we have to disclose. The principal is also a licensed agent, right? Or broker, right? That's a disclosure we have to provide. But I've seen where sellers get attorneys involved, and the attorneys dissect it, turn it around, and accuse you of misleading the seller, which in most cases, if you disclose what the intent is, then you're covered. And when I've done investment properties, or anyone that is looking to buy investment properties, I always say you want to put this as part of the agreement, that you're buying the property below market value. Your intent is to, fix it, and then ultimately to make a profit on it. So you're now protecting yourself from all those elements of sellers saying, well, I didn't know. One, you're telling them that you're buying the property below market value, right? And they know the property's in really bad shape. And I'm talking about a property that's going to take $100,000, $200,000 to renovate, right? Because it's not in good moving condition, right? So they'll know that they're selling a property that needs repairs. But you still want to have that layer of protection, right? That you're disclosing because you cannot predict the future, right? And if they come back and get an attorney, the attorney is going to dissect and going to say, did this buyer's disclose what the real intent, or that they mislead the seller, right? And now, not just is the buyer involved, but also the listing agent can be involved in a litigation. Okay, so it's best to just disclose in the transparency of the contract. What is the intent? Okay, because now they can say, well, the listing agent also knew about this, and they're going to entangle you into a lawsuit. It's far and few, but does it happen? Yes. So all I'm saying is, disclose what the intent is, that you're buying the property below market value. The intent is to renovate the property. And then, thirdly is for the benefit of making a profit, which is perfectly fine. Look at how many cars that classic vehicles people buy, right? Restore them and then turn around and sell them at a higher price. That's all you're doing in real estate. You're not doing anything misleading. You're not doing anything unethical. You're trying to buy a property that ultimately you can get your money back and make a profit from bringing it from what it was to what it is now, right? Move-in condition. So there's nothing wrong with that practice, but it's those 1%ers out there that may see it differently, may get a little bug in their ear saying, well, we have a case here to sue because they did not disclose. That's all I'm saying, okay? Transactions happen. And here, as paragraph 23 says, is that even if you're gonna wholesale it, to another investor, we have to divulge that information. One, who that entity is. If it's buyer Smith now selling it to buyer John, we're going to identify that and give that to the seller. But also, if there's going to be a spread, right? If I'm buying it for this and selling it for that, again, disclosing that doesn't mean that the seller can come back and say, well, I want the difference now. Okay. Well, that's your expertise, right? That's why you put that language in there, that there may be a chance that you may sell it to someone else. And there has to be some type of amount of spread, right? Because maybe your contractors, right, may give you a bid of 200,000, but someone else may have another contractor that their bid is 50,000, so they can pay that difference in the wholesale fee and still make it work. Okay, because if I get two or three contractors, they're all going to give you different quotes, right? If I get two appraisers out there, they're going to give you three different evaluations, right? If I get three agents to give me an opinion of value, guess what? They're also probably going to give you three different opinions of a value, right? That's what we're just trying to disclose. I know it's a little bit interesting, and you probably have lots of questions to ask. I'm only going based on what the contract says, right? And paragraph 23 does go into it deep. And then there's another form, right? And that other form is the OAA form. Let me pull it up real quick. Did I miss it already? Where is that form? Here it is. Okay, so here's the form, assignment of agreement addendum. Okay. So here is full transparency, full disclosure to all parties. What is the intent? All right. The following terms and conditions are hereby incorporated and made part of the purchase agreement or any other, right? If it's a land purchase agreement, if it's a commercial, then you're going to divulge that information between buyer and seller, right? Paragraph 1 and paragraph 2 talk about parties or responsibility, right? 1A says partial assignment added. Adding a buyer. Buyer is adding the assignee's name below to the agreement and granting such assignment as a partial interest in this agreement. Let's say that the intent is that it's a husband and wife, right? But the buyer is only the husband, but now you're saying, well, I want to include the wife, or I want to include a family member. So you're going to include as a partial. Now you're still involved, but you're adding a second buyer to this agreement. Does that make sense? Okay. Section B talks about total assignment. If it's a completely new buyer, or we're deleting a buyer. Buyer is assigning all buyer interests in the agreement to the new or remaining buyer assignees named below. And then you're going to put it here. If it's John Smith now that's going to be buying this property, we're going to divulge that. Even though it was Jimmy Johnson, right, who originally submitted the offer, but now we're going to sign it off to someone else. Okay, so that section there is where you're going to put it as a disclosure. And then section D as in David, assigning is my buyer's own trust or own entity. Okay, so if it's a trust that you're putting it on, then you're going to check that, and then that's going to tell the seller and the listing agent that it is your personal corporation, S Corp, C Corp, LLC, or my own personal trust. Okay. Then it goes into delivery of prior documents, right? Prior documents already delivered to assigning. Assigning acknowledges that the buyer has already provided assigning all prior documents. If checked, documents not yet delivered to assigning, seller shall deliver to buyer an assigning or seller signed copy of the assigned agreements or addendums upon receipt of the seller's signed assignment. So once this signs, then you can divulge all that information to the new person involved. Time to return assigning initials prior to documents. Initial copies of all prior documents are attached to this assignment. Assigning shall deliver initial copies of all prior documents to the seller within 3 days after seller delivers to assigning a signed copy of this agreement. Okay. Effect of failure to return or attach documents. Seller after first delivery and notice to perform. Remember that 17 days on section K, I think it was K as in King. First page of the RPA, where it is assignable, right? And it has a contingency period to do so, right? Which is 17 days. After that 17 days and buyer releases any and all contingencies, that also includes assigning it or wholesaling it, or even possibly adding it to a corporation. What now that stipulates is that the buyer has to close out the deal with that person's name. And ultimately, they're going to have to do it outside of escrow if they're going to now transfer to a corporation, S Corp, C Corp, LLC, or if they're wanting to create a trust. Does that make sense? Okay. Consideration for assignment. Here it is. Buyer has received consideration for assigning. This is the language right here, Steve, that, I get what you were saying about, well, I don't think that's, the common practice. Well, it is.
No, it is.
Anything and all that we do is transparency. So even though the person assigning it is going to make a spread or a wholesaling fee, and that's a common word in the investment world where I wholesale it. I tie up the property for 100,000, but I'm going to wholesale it to this new person that's going to buy it for 150,000, right? I'm making a $50,000 spread, which is perfectly legal to do so. Agents do that all the time. You can do that, but transparency is that you have to divulge that information, and the seller needs to know what the intent is. And here it is. Okay. How much are you making out of that spread? Well, geez, I'm going to make $50,000, right? Not 500,000. Thousand as an example, right? And it varies from, transaction to transaction, depending on the severity of the condition of the property, right? The worst properties obviously give you the most return on your investment, right? Because you're going to go in there and basically gut the property, right? But the intent of this agreement, no difference than the RPA, is that it is assignable, but it also has to be approved by the seller. If it's your own entity, then you don't have to assign it. You can just do so by your name, and then in escrow do an addendum, and then escrow will do an amendment saying that we're transferring to it. But it also says that the buyer has 17 days to do so. So after that 17 days, an addendum is created, we can argue that fact that the seller says, well, I don't give consent to that, even if it's your own personal corporation or trust. Because then we could go back to the agreement says, well, Mr. and Mrs. Buyer, you had 17 days to do so. You released that as part of the contingency. Therefore, we don't agree to it. Now, I don't see who would say no to that if a seller would say something, no, I'm not going to do it if it's going to be their own corporation or own trust, right? Because they're still going to close. They're still responsible. And more so, you know, their deposit may be in jeopardy if the buyer has released all contingencies, right? So I don't see that the seller or the listing agent would argue that fact.
Other than a time frame.
Yes, sir. Exactly. But you can argue that fact if, you know, the buyer's agent has been a very difficult, you can argue the fact and say, no, you're going to have to close it out with your buyer as buyer A. Okay. So that's what the contract says.
So this addendum only gets, I guess, added if a change is being initiated within that 17 or contingency time period, whatever it is.
Yeah,
It's not in conjunction with the RPA submission.
that's correct. Yeah. Now, the question is, what if it's 18, 20 days? Well, if the listing agent hasn't been on top of the days of contingency removal, then shame on the listing agent for not. So it could be 18, 20 days. If the buyer hasn't released that part of the contingency period, then the buyer has the right to ask for an assignment to their own corporation or trust, or even, you know, transfer it to another buyer. That's why you got to be on top of your contingency periods, right? Because once the 17 days, you're going to send out the contingency removal, releasing, you know, physical inspections, appraisal, loan, and any and all, which includes this paragraph 23 of assignment as well. That's why they added that to the new purchase agreement, is that section that it is an assignment. It doesn't say yes or no. It says that it can be done, but it has to be consent by both the seller and the buyer of what their intentions are, but it's perfectly legal to do so. Okay. Section 456, assignee represents by the benefit of the seller. The assignee rectifies the approves as the assigning's own act all prior approvals and acts of buyers pursuant to the agreement up to and included the date of this agreement. Assignee assumes and agrees to perform and observes all the obligations and covenant of the buyers in this agreement to be performed. So for example, I'm the buyer, right? And I'm buying at Simon Casares or Assignee, right? After doing my calculations, I just think, gosh, this is just not a good investment for me based on what it's going to cost me, right? I'm now going to say, I'm going to assign it to Jimmy. Jimmy goes in there, does his calculations, gets his contractor, and the contractor says, yeah, I can do it for this. And he says, okay, I want to buy it. I cannot pull out, or I can't even pull out my deposit. The deposit stays in there. Okay, the deposit stays in escrow. The new person, all right, will have to put in their deposit. And then once that deposit is in escrow, then escrow can now cut a check to me releasing my deposit. Does that make sense? Okay. Again, transparency, everything involved in the initial transaction. Okay. And that's perfectly fine. I'm putting 20,000 in deposit in good faith that I'm going to purchase. But if I assign it and I get the okay from the seller and this new buyer comes in, they're going to put in their initial investment, which is 20,000, right, as the original agree, because everything coincides with the original purchase agreement, including close of escrow, okay, terms and condition, and also the deposit. So if there's 20,000 in deposit, they have to match it or increase that amount. And if I'm getting a spread, right, a wholesaling fee, then again, here's the form that needs to be provided. And, ultimately I'll get my 20,000, but there may be a $10,000 wholesale fee that I'm getting from selling it now to Jimmy, right? Then Jimmy would be responsible to a certain extent, right? For closing out once my deposit is pulled out and everything has been done properly. Okay. Buyer acknowledges and agrees that notwithstanding seller agreement to this agreement, buyer is not released from any obligation or covenant under this agreement, right? If there's any other terms, without releasing buyer from any obligations under this agreement and preserving all rights and remedies under this agreement, in consideration of the covenant contained here, seller consents to the following foregoing assignment. That parties acknowledge and agree that they have been advised to review the assignment with a qualified California real estate attorney or accountant prior to signing this agreement. Again, the importance of all this stuff, right? Because I've seen this firsthand where people get in trouble and now they're trying to sue. I remember one case where a agent, not here in KW, but an agent saw the potential of buying a property, bought it straight from the seller, and offered X amount of amount to purchase the property, closed the deal, went in there, spent about $50,000-$60,000 to renovate it, but ultimately put it on the market immediately, and then sold it and made like $300,000. Okay, when the previous seller found out about that, got an attorney, sued the buyer, sued the buyer who was also licensed, and said, look, you never disclosed that your intent was to make all this money. I'm entitled to some of that money. And guess what? She had to pay the entire profit she made out of it back to the seller. Yeah, the entire. Yeah, it's bonkers, but that a true story, which again, the fees investment she was able to retain, but the actual profit she had to get back to the seller on the lawsuit. Yeah, so she ended up settling and paying a substantial amount. So again, full disclosure, folks. All right, any questions regarding, and here's the original buyers, right? And then the new buyers who are being assigned to will sign below here. So if buyer A is the original, then buyer B would be signing just below that. Okay. And then obviously the seller consents to the assignment acknowledgement. The seller has read, understood, received a copy of this agreement, right? Full disclosure, even if you're making a wholesaling fee, right? Which is fine, it's legal to do so, but you're also divulging that information to the seller. Okay. Any questions?
So going back to the original slide presentation where it said nominee or assignee, it looks like the car had indicated that the two words are now interchangeable.
Right.
So whether a buyer puts on the top so-and-so, Mr. John Smith, or assignee or nominee, if they want to make any adjustments to it, they have to do that form.
That's correct.
Okay.
Yep, that is correct. Let me share my computer one more time. Hopefully I didn't lose that section. Hold on. Yeah, I think I did already. I know, right? Yeah, full transparency is if the buyer's intention is that's what you're gonna put it. So let me go back and just check on something.
Simon, you'll be happy to know that the assignment, when I was talking to you about a year ago, my buyer ended up adding an assignee. So he went on. So there was no non-disclosed profit in the transaction or anything. So we're all kosher.
Yeah, I appreciate it, Steve. By the way, I love the beer.
Thank you. I joined the club.
Yeah, you sure did. Last year you were clean cut. This year is like, bam. All right.
That's it.
Let me go back to the purchase agreement real quick and So here we go. God, so many paperwork nowadays. So where are we? Okay, right here, see, section K 23, assignment requested. So I don't know if
It's not a
in the picture, if
contingency.
you see the gray area here that they may include something in the future, you know, just because there's a section there that maybe in the future, maybe in June, maybe in December of 2023, they may add, you know, specific additional terms on this. But for the time being, an assignment requested is automatic. Okay. It already automatically allows the buyer to do an assignment request. Okay. Just a request doesn't mean that the seller has to agree to that request, but it allows you to automatically do that. But it also says 17 days, or you can put a specific amount, maybe 25 days as an example. If the seller signs off and accepts the terms of this offer, then you're golden. That's your protection, meaning that you have up to 17 days or up to whatever time frame to assign it to a different party, and that includes your own corporation and your own trust. Make sense?
So could a person technically put a check mark there or put a timeline there, but not actually use the verbiage on the buyer's line of or assignee?
Well, that's where a counter offer would come into play.
Well, that's what I'm wondering. So is it then up to the listing agent to go through and look for section K, just to make sure there's nothing there? Or should
There's
the buyer
nothing,
be-
yeah, there's not, that's why I'm saying that in the future, you see the gray area, maybe that's where they're going to be able to put some type of language there, either a check mark or something. Right now, you know, it's blank, but I believe something is going to happen. If it doesn't happen in June, just like L8, see that gray area? They may start adding more stuff. Right now, it doesn't have that, but on additional terms, which is right here, other terms, here they can put that, and where I can see it from a listing agent's perspective. Okay, so I see something here, because I've seen buyers put something that the buyer's intent is to have the right to include a vesting entity. I've seen that language added, and you can put it on additional terms here as well. And that entity can be, it's like a wholesale, it's like assignment. But most people may say, well, you know, I'm getting married, you know, and part of that is that maybe after I might change my name, as an example, right? So that may be the situation. Right now, you're John Smith, but you know, in a couple of weeks, you may be John Casares, as an example, right? So that's where you would put that specific. Okay. Any other questions? Cool. All right. Well, that concludes today's. I hope this information was of some understanding. I know it's a little confusing, but if you do have any additional questions, by all